Welcome back. When I talk about estate planning and just say it to a lot of clients of mine, you get a bewildered look many times. And I think a lot of it is just because it can be very overwhelming and something that ultimately talks about not being here anymore. And so what we really want to try to do today is just, hit one little area, try to make it clear, and also be able to tell people how we can get stuff done. So we are joined by our estate planning expert, Bridget Mullaney from Cameron Mittleman.
Thank you for having me.
You're welcome. You're welcome, and welcome back.
Thank you.
And today we're going to talk about revocable trusts and trying to educate them and our viewers. So can you tell us first what a revocable trust is?
Yeah, a revocable trust is a common tool that's used in estate planning, and I like to look at it as it's a set of instructions. You're telling people how your assets are supposed to be used during your lifetime if you're ever incapacitated, and what happens to your assets when you pass away. And as the title of it says, revocable, you can change it at any point or modify or revoke it. So
you just get rid of it too?
You can just completely get rid of it. So it's a great tool to use during your lifetime.
Yep. And I like kind of what you said, because a lot of people think the word trust always is just very convoluted. And I almost tell people before they come see people like yourself that really you're leaving your instructions, and you're kind of putting some sort of merit behind that because it'll uphold itself.
Yep, correct.
So,
yeah.
So the revocable trust has a lot of different features to it. So what are some of those common features and how do they work?
Yeah, one of the main reasons people are using revocable trust is because you want to do some type of, asset management. You want to protect your assets from going through probate, to minimize estate taxes, privacy, and also managing assets for minor children.
Okay. So tell us a little bit. So when it comes to asset management, exactly what does that mean?
Yeah, the way it kind of, if you think of a trust as kind of a bucket and you're putting all these different assets in there, and then you having someone as a trustee who's kind of in charge of what happens to the assets that are in that bucket, so that if you ever become incapacitated during your lifetime, someone can automatically step in and start paying your bills or make investment decisions. And then after your death, what they're really doing is kind of, okay, now everything is under one bucket, and now we can, disperse them as they need to.
Now, one of the things you had mentioned in there, just so I understand this, is that if I became incapacitated, obviously that person that I've named could kind of step in and fill my role. If I don't come incapacitated, do they have any right to that money or no?
Your beneficiaries don't have any right to that money unless you say that they're a beneficiary of it during your lifetime. But normally that money that's there is, if you have a trustee, their job is to use that money for your benefit, not for their own benefit.
Okay. And so you also mentioned estate tax planning. So in a revocable trust, how does that work?
So typically when you have a married couple that's coming in, one of the reasons we try to is to utilize their exemption amounts. So in Rhode Island, you have an exemption of roughly 1.6 million in Mass.
Always changing, right?
$1 million, yeah. Rhode Island doesn't keep it as a nice even number. So one of the ways that we use a revocable trust is really to make sure we're sheltering that exemption amount so that ultimately passes down to your loved ones estate tax free.
So in a sense, you're doubling it, or you're not. If you've got two spouses, they each have that exemption.
Correct.
But if you don't put it in a trust, once the first one passes away, now there's just that one part left where you could actually get double the coverage.
Correct.
By having that revocable
Correct.
trust. Okay, and then we talk about probate avoidance, and I think that's to me that's something that people are aware of. But what does that actually mean?
So typically, if you have an asset in your name alone, like let's take a piece of real estate, you might own it jointly with your spouse. When one spouse passes away, now the surviving spouse has it in their name alone, and that asset can't be passed to your loved ones unless you go through court. So if the house is actually owned in the name of the trust, we can bypass going through probate court, and we can actually deed that property out to your loved ones without court oversight. It also comes in really important when you have real estate in different states. So for example, if you have your primary residence in Rhode Island and you have a vacation home on the Cape, if you pass away and you have your Cape home in your sole name, you have to open probate in Massachusetts as well as in Rhode Island, which can get very expensive and time consuming. So, simply deeding the Cape property into the trust, you can avoid probate in Massachusetts.
Okay, and now what if you have, and that would help if you've got multiple properties or anything in any states, correct?
Correct, yep. So I've had it happen sometimes when people have had property in Massachusetts, they've had it in Florida, Colorado, and you end up having to do probate in, 4 states, and that can get very expensive.
So would it be accurate to say that by doing this sort of work up front, that you're actually paying up front in probably getting it much cheaper than if you actually had to go through probate.
Correct, yes.
But it's actually, and again, I find this is it's difficult for people to face that, so they first got to get there.
Yeah.
And one of the things I wanted to say in the beginning was, and this is just my personal experience with my clients, is from the day that I talk to my clients about estate planning to the day that they actually sit down with an estate planner and get it done, I don't know the exact number, but it's got to be about 5 years. And it all depends on the complexity, but even the most general stuff, it's because we don't want to face it. And earlier in their life, it was about not getting life insurance because you don't want to think about dying. But now that people get older, they tend to do it a little bit later in life, even though sometimes they should do it earlier. But it's kind of getting over that, and it's a quicker process, I think, in the most cases than most people think it is. It's not, you're not dragging them through the mud as much as they might imagine.
No, it's usually not, a laborious process. It's just a matter of getting there, and as you said, it's not the best topic you want to talk about on a Friday if you've had a, busy life, you've been working, you got kids running. I mean, that's,
Yeah. And you had mentioned, and again, I never think of this when I think of the revocable trust, but it's a way in which you could actually protect the assets if you've got minor children.
Yeah. And that's a big reason I see people come in, because a lot of people say, I don't have enough assets to warrant having a trust. And I often say, if you have a minor child, do you want your child getting it at 18? And most people, even though say, my 18-year-old is not financially responsible enough to have these assets. So it's a way of saying, they're going to get it in stages, they'll get it at a certain age to make sure that money is used if you want to make sure they go through college or so forth. And so
you actually, guardianship is not usually built into a trust, correct?
No, a guardianship is usually covered under a will, but what happens is who's going to manage the money for the child's benefit, and that's where you can have someone who might make the best decisions for them. Day-to-day decisions might not be the best person to make the financial decisions, so sometimes the guardian is different.
Okay, and would you say that, like, if someone actually does go ahead and does the trust, and I think many times if they're in a professional's care, they're going to get a trust of will, powers of attorney, and they'll get everything covered. But some people, and I don't even know, can they do a trust on their own if they really wanted to?
They can. It's very uncommon with a revocable trust just to do that without having the other estate planning documents in place, but it's possible.
Okay, and then if they were to do it themselves, here comes the question of they might think they don't even need a will. So it's still important, even though a will's more basic, I would assume it's still important that they not only have the revocable trust, but they have to probably have a will?
Yeah, a will, you don't have to have a will, but the will is really kind of protecting things. If you have something out there, there's usually some asset that's outside of your trust, and it's just kind of a catch-all, and it's just going to direct everything goes to the trust.
Okay. All right, and so let's say our viewers said, hey, I think this is something I need. However, the thing that's holding me back is I think once I put this into this trust name, I lose control of it. And we talked a little bit about that, but do they lose control of it in the revocable?
They don't, not with a revocable trust. During your lifetime, you have control over the assets. Again, going back to that bucket, you can take things out of that bucket that you put in, and you can get rid of the trust if you want, so you don't lose control over it.
Okay. I think I've been saying it wrong for 20 years. You're obviously saying it right, revocable.
Yep.
And I say revocable. I say revocable. And
people say it different ways.
Okay.
I think we're all talking about the same thing.
I think I might be saying it the wrong way. All right, so once a trust is completed, what is the next step for them? So a lot of times they'll say you need to fund the trust. What does that mean, and what does that process look like?
So again, it's a two-part process. Part one, you get the instructions in place, you sign the documents. Part two is, okay, you have that real estate that's down in Florida. You need to do the deed that says that property is no longer owned by you individually, but the name of your trust. If you have a bank account or an investment account, making sure that investment account is in the name of the trust. And that's not a complicated process. It's just a matter of working with advisors such as yourself to make sure the assets are retitled.
Okay, and for, like, let's say they just have a general account at a Citizens Bank and they don't have an advisor there. Is that something that's pretty easy for them to do?
Yeah,
Are they bringing that document down once it's done?
Yep, we typically provide like a one-sheet page document that kind of gives instructions that they can hand if they go into a bank and say, this is what I want to do, and then they'll walk them through it. So.
Gotcha. Okay. All right, so let's look at the converse side of a revocable trust, or revocable, as I say, irrevocable. I would assume that's the opposite. So and again, I know we could have a whole episode on that, right? But just from a high level, what's the comparison of the two?
Yeah, an irrevocable trust, as you said, you can't change, and you lose some of that control aspect that you have with a revocable trust. And people use an irrevocable typically for asset protection. So protecting assets if you go into a nursing home, or to get assets out of your taxable estate so that when you pass away, they're not going to be included for estate tax purposes. Those are the main reasons, but there's, a variety of other reasons, and as you said, it's a complicated
Right, no, I know.
topic.
But a revocable trust itself, I think, just to clarify, because I have people that come to me all the time and say, hey, everything's protected, it's in a trust, and they don't remember whether it was revocable or irrevocable, and then we find out it's revocable, and they don't have the protection that they thought that they had. So it's important that they understand what they have.
Yeah, I think it's important. I think if you think of it this way, if you have control over the assets and you can take the assets out, you're not going to have creditor protection. You're not going to be able to protect it from a nursing home because you can pull the money out. If you can't pull the money out and you don't have the full control, then you're likely have some, creditor protection there.
Got it. Okay. All right. So lastly, one of the things is also understanding how does someone know that a trust is right for them? So and again, I know every individual is a little different, but in general, if someone comes to you and you be like, okay, this is where this makes sense. So if someone out there is listening, be like, I don't know if I need it. I don't really want to sit down with somebody, to try to figure that out. What could be some general guidelines?
I mean, I think generally, if you do think you're going to have any type of estate tax issues, then you certainly, want to consider a trust. And people need to remind themselves that they, life insurance, retirement accounts are included for estate tax purposes. And that's the other thing is if you do have minor children, that regardless of kind of your asset level, oftentimes just having minor children is.
Great. Well, we appreciate all the great information that you have there. When we return, we will talk about the snowbirds and how to protect yourself, or actually how to fund yourself when you're ready to make the move. We'll be right back.